So, Jai Bhim to all of you. Today we will be uh, discussing very important aspect of our 6 weeks course on Constitution and Constitutionalism as framed by Baba Sahib Ambedkar in the book plan that is available to us. And so far we have covered a lot of ground. We have covered four essential aspects of the thoughts of Baba Sahib Ambedkar on Constitution and Constitutionalism. And today we will be looking at a very important aspect of the Constitution and Constitutionalism, of course, with view to the exposition of the principles of the Indian Constitution. So let me go to the presentation. So this is what we will be discussing today. 1 minute. So let's begin our discussion. And as I said, that today we'll be discussing about the state and citizen as a broader category. But within that, there are a lot of things which are very important for us to understand, and they are so vital to understand the Constitution of India and the principles underlying therein. So the subtext of the today's session is Constitution is the rule of law. So before I go on to discuss the topic today, I thought, why we or Baba Ambedkar is talking about the principles underlying the Constitution, because I think this is a very remarkable statement of Baba Ambedkar in 1955, where he says that if I may say so, and I say it with certain amount of pride, the Constitution which has been given to this country is a wonderful document. So the Constitution, as according to Baba Ambedkar, is a wonderful document. And it has been said so, not by myself, but by many people, many other students of the Constitution. It is the simplest and the easiest. Many publishers have written to me asking me to write a commentary on the Constitution, promising a good sum. But I have always told them that to write a commentary on this Constitution, on the Constitution of India, is to admit that the Constitution is a bad one and an ununderstandable one. It is not so. So anybody would like to understand the Constitution of India, they don't need a commentary, because the Constitution itself is a self explanatory, and one can, as Baba Ambedkar says, if anyone who can follow English can understand the Constitution. It's as simple as that, and no commentary is necessary. So you see, the lectures that we are conducting is not a commentary on the Constitution of India. It is the exposition of the principles of the Constitution, particularly from the point of view of the Indian Constitution. And that's what I wanted to bring to you, before the start of this fifth session today, as to why we are conducting this exercise. So what is it in this lecture today? So we are going to look at, understand, and study the understanding the rule of law. We are trying to understand what is the rule of law. And then we will be looking at the rule of law briefly from the point of view of democracy. And then, of course, citizenship and rights, how they are interrelated. Even the rule of law, how it is related with the citizenship. Then we are going to look at the rights and remedies, because without remedies, the rights are useless, as we are going to see. And then I'm going to demonstrate Baba Sahib's aspect of right to personal freedom and his general concept of personality. And then rights and justice, that's I'm going to touch upon briefly today. And then one example of right to property, and then rights and economic justice. So this is what is going to be our framework for the lecture today. So let's go to our content of the lecture today. So this is what Baba Ambedkar has planned to write when he planned the book. And in the part 4 of the book that he wanted to write, these were the chapters. Like the chapter 11 was to be related to the rule of law. And then right to personal freedom, right to freedom of speech, right of public meeting, right of association, right of free movement, and right to hold property. These are all rights which are given in the Constitution of India, and much more than that. In the Constitution of India, as I'm going to show you, it includes many rights. But in the context of the principles of the Constitution, this scheme is very important, and it doesn't begin with the rights, but it begins with the rule of law. So underlying the rights is a very key concept called the rule of law. So let's look at the conceptual framework of the rule of law. So what is the meaning of rule of law? And as we know, Dicey, the British expert on constitution and law, has written a lot on the rule of law. It is said that sometimes it is said Dicey's rule of law. It is, the rule of law goes hand in hand with Dicey. And the rule of law has become the part and parcel of every country, including the China. Whenever they talk about, their political system, they talk about rule of law. Every nation talks about rule of law, and therefore it's very important for us to understand the rule of law. And Baba Ambedkar was, of course, has read widely, and he has had, read Dicey's work and his concepts so deeply. So you see, what is the rule of law according to Dicey? So he says that rule of law then which forms a fundamental principle of the Constitution. Now, this is a very important statement that the fundamental principle of the Constitution is the rule of law. Now, bear this, proposition in your mind that it is the fundamental principle of the Constitution. And I'm going to show you that it's not, it's in the contrast with the rule of people or men or the rule of a group of people. No, it is not. The rule of law is the fundamental principle of the Constitution. And according to Dicey, it has three meanings, and it has to be looked at from the three different point of view. So one of it, I'm going to read it through and through because it's very beautifully explained here. It means, in the first place, the absolute supremacy or predominance of regular law. So it's the supremacy of the law, it's the predominance of the law, it's the rule of law, as opposed to the influence of arbitrary power, isn't it? So you cannot have the rule of the arbitrary power. And what does it do? It excludes the existence of arbitrariness, of prerogative, or even of wide discretionary authority on the part of the government. So according to the English Convention, Englishmen are ruled by the law, and by the law alone, a man may with us be punished for a breach of law, but he can be punished for nothing else. So if there is to be any punishment to anybody, it has to be according to the law. There is no way by which you can punish an individual arbitrarily. So, this is a very key concept underlying the Constitution, that it underlines a very important fact that the rule of the law, the supremacy of the law, the predominance of the law is the key or the fundamental principle of the Constitution. Now, the second principle is very interesting and important, is equality before law, or the equal subjection of all classes to the ordinary law. There is no special law for anybody. Even the prime minister, whoever they are, even the president, the king, the businessman, whoever they are, the capitalist, they are the same compared to the rickshaw puller, or to a beggar, or to labor. It's same. There is a equality before the law. It's a legal equality. The law cannot discriminate between the people, between the citizens, as I'm going to show you. And the third aspect of the rule of law, lastly, may be used as a formula for expressing the fact that with us, the law of the Constitution, the rules which in foreign countries naturally form part of a constitutional code, are not the source but the consequence of the rights of the individuals. You see, so the Constitution, as we have seen in the other lectures, that it puts the individual at the center of the Constitution, and we have seen how Baba Ambedkar has done it. But here, suffice to say that the constitutional code are not the source but the consequence of the rights of the individual. So you cannot have the Constitution without having the rights of the individual inbuilt, and the rights of individual are connected directly to the rule of law. And so I think this is a very important principle that we have to bear in mind. So this is what Dicey says. He says the Constitution being based on the rule of law, the suspension of the Constitution, as far as such a thing can be conceived possible, would mean with us nothing less than a revolution. So if the rule of law, that means the Constitution, is sabotaged or suspended, then it's nothing less than a coup. So anybody who is talking against the Constitution, saying that the Constitution is like this or like that, they are actually threatening the very existence of the country, because the existence of the country depends on the rule of law, the rights to the individual, and that is the source of the Constitution. So I'm going to summarize here the three elements of Dicey's rule of law. One, procedure established by law, due process of law. As we have seen that nobody can be punished arbitrarily, there has to be a process. There has to be a procedure established by law. According to the American Convention, there has to be the due process of law. So it's very important to determine what are the circumstances in which a person can be properly punished or made to suffer some personal loss or deprivation under the law. So the law is supreme. There is a preponderance of the law. Then, as I told you, everybody is equal in the eyes of the law. There is the legal equality that no one, whatever is the rank or title, stands above the law. This is what is important. And constitutional supremacy is another aspect of the rule of law, and the rights of the citizens as generalized written laws. So, they are not arbitrarily. The laws, the rules, the rights that we have, they are not coming arbitrarily. They are written, encoded in the Constitution of India. So this is, I think, is a very important summary of the DICE's rule of law. Now, just to broaden the scope of rule of law is opposed to the rule of man, the rule of person. So what is the rule of law? Is the written law rather than the will of any particular person or group. It is authoritative source of power in Indian system of government. So the constitution, the written law, is the ultimate source of power. And that is what we are ruled by. We are ruled by the law, not by the man. And the law can be changed by methods that are themselves prescribed in the constitution and the laws. But while it is in effect, the law is binding on all. So the law must be binding on all. And as we know that the Indian Constitution is a written document and a formalized system defined by written text, and all the act must constantly be measured against it. So all the legislations, all the things happening in the name of the law has to be measured against the Constitution. And the Constitution as a law is a set of constraints or structured boundaries on power. So it puts, as we have seen in the previous lecture, it puts certain constraints on the different organs of the government, and it is, as it is said, structured boundaries on power. So Indian Constitution, as we know, is a right-based constitution. And the rule breaker can be government. We have certain remedies that we are going to see briefly as to how, when our rights are, our rights are snatched away, what can we do? So, this is a very important point to understand. So I put in this slide some of the important quotations by the great people, like Thomas Paine says that as in absolute governments, the king is law. So in free countries, the law ought to be king. So, the law is the king. King is not the law. Law is the king. That is very important. And, that's what Thomas Paine very clearly explaining what is the rule of law. This is what Baba Ambedkar says, a theory which leads to such a conclusion that men have no right but what in power choose to give them must be doomed to be fatal to any form of popular government, and as such I reject it in toto. This is what David Hume says. The rule of law is the foundation of just society, isn't it? So politics is haggling or it is force. This is Daniel Bell, sociologist. So very instructive that whatever people cannot usurp the power. The democracy has to be done with discussion, negotiation, and then Daniel Bell calls it haggling. Otherwise, it will be by the force of the men, and it is not principle of the democracy as we have seen. So, Constitution, as now we have seen, is the rule of law, and the personal rights are there, and limits on the power of the government are established. So, some of these are expressed as personal rights, as I'm going to show you. That some of these, aspects of the rule of law are expressed as personal rights, in effect defining spaces around individuals and communities into which others or government may not enter. So there is a personal space, individual space where the government cannot enter. Of course, subjected to the reasonable restrictions as there are in the Indian Constitution, like law and order, public morality, and so on and so forth. I'm not going to go into what is actually there in the Constitution, which you can read, and I'm going to share a copy of Constitution with you in the group, which is very, very instructive. So some of them are expressed as definitional constraints on the institutions of government, placing broad categories of governing power. And the Constitution, as we have seen, defines a legislator, an executive, and a judge, and sets limits on their power. It's very important. These are all aspects of the rule of law. And the Constitution as a rule of law defines boundaries, and judges interpret and patrol those boundaries and insist on their enforcement. So this is just about constitution as a rule of law. Now let's look at the democracy and the rule of law. So there's a very important statement by James Wilson at the American Constitutional Convention where he says, can we forget for whom we are forming a government? Is it for men, that means includes men and women, or for the imaginary beings called states? So the government is formed for the people. So the government must serve the interest of all the citizens considered as political equals. And this is what James Wilson. So I just to begin our discussion on this topic, I had put the quote. So republicanism and rule of law. As we have seen in the previous lecture, what do we mean by republicanism? It's a democracy that can be expandable to the beyond the geography, to the what geographical extent, and it's a very important aspect. So what is the connection between republicanism and the rule of law? Democratic republic in any form has to be a rule of law. It cannot be arbitrariness or given to the certain group of people. So this is a very important aspect of it. And as I said, just give me 1 minute, okay? So let's look at this. Republicanism, in both classical sense and modern form, runs far deeper than representation. So it is not just representation. As we have seen republicanism in terms of the representation also, but it is not just representation. It goes deeper. It is a civic ethics, not just a system of government. And at heart is the idea of human being and citizen that emphasizes our responsibilities to one another and to the common good. It is not just what we each want, but what is good for all of us. These are all underlying principles in the Constitution. In this context, the fundamental rights, if we look at our principle of representation, republicanism, and as a civil ethics, so the fundamental rights, particularly right to equality, freedom, and life, they form the golden triangle of the basic structure of the Constitution of India. In other words, our preamble states, the framework as to how the republicanism is based on this principle of, what is good for all of us, and it constitute, as it is clearly worded in the preamble, justice, liberty, equality, fraternity, dignity, and the integrity of the nation. These are not just words; they are very deep concepts that we need to understand. So to take further, what is it? The rule, predominance, and supremacy of the law, and the rights are the gift of law. That's what Baba Ambedkar says. It's a gift of the rule of law. To expand the definition further, and the rule or supremacy of the law is very important, and security given under the Constitution to the rights of the individual, they cannot be violated, and absence of and check on arbitrary power on part of the government. That's what the rule of law does. And as Baba Ambedkar says, fundamental rights are the gift of the law. So whatever fundamental rights we have in the Constitution, they are given by the rule of law. They follow from the rule of law. They don't follow from the group of the people. They don't follow from any arbitrariness. They follow from the rule of law. And as Baba Ambedkar says, while non-fundamental rights are created by agreement between parties, various groups, various parties. So this is just to expand on the theme of republicanism and the rule of law. We are going to look at the citizenship and rights. This is what Baba Ambedkar says in 1919, as early as 1919, that what is the citizenship. And we have to bear in our mind what constitute a citizenship. So if you look at the structure of the Constitution, it's also instructive that the first part of the Constitution defines what is India and as a federation or the union of the states. In the second part, it goes into defining the citizenship, and following that are the fundamental rights, and following that in the part 4 are the directive principles of the state policy. But even the structure of the Constitution is very important. So the citizenship is directly linked with the fundamental rights, and this is what Baba Ambedkar says. Citizenship, what is citizenship? Is a bundle of rights. So what is citizenship? It's a very deep concept of citizenship. If I'm an Indian citizen, I have to have these rights. It's not just having a voting card, or even it's not just having particular documents that qualifies me to be an Indian citizen. I should have the bundle of rights, which includes, according to Baba Ambedkar, personal liberty, personal security, right to hold private property, equality before law, liberty of conscience, freedom of opinion and speech, right of assembly, right of representation in a country's government, and right to hold office under the state. So you see, these 9 rights and the bundle of that taken together form the citizenship. And this is what Baba Ambedkar is saying as early as 1919. And this has a very deeper consequences. So, as we know that when the Constitution was written, we have this set of rights and right to equality, we have right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property, right to constitutional remedy, very important, Article 32. But if you look at this, they are not just the personal rights, but they are also social rights, ensuring social justice. There are rights which ensure the political justice, but there are no rights to ensure the economic justice in the Constitution of India. And I'm going to show you how Baba Ambedkar tried to do that through the DPSP, the Directive Principles of the State Policy. So these are the rights given in the Constitution. So I just put this just for the sake of information, that these are the fundamental rights in the part 3. Article 12 is of course definition. 13 is of course law inconsistent with or in derogation of the fundamental rights. Then, as I said, right to equality, it constitutes 5 articles, including the Article 17, the abolition of untouchability. It's like for the social justice. And these are very important. The way they are arranged is also very important. And then we have Article 19. It stipulates certain rights regarding the freedom of speech. And there are 19 specifies a lot of interesting set of rights for the citizens. And of course, the Article 20, protection, respect of conviction for offense. And Article 21 now elaborated, including a lot of rights, protection of life and personal liberty, right to housing, right to health, so on and so forth are now included through right to freedom, right to Article 21. And then of course Article 22, and these are the right against exploitation. There cannot be slavery in this country. No, there cannot be traffic in human beings and forced labor. In other words, there cannot be slavery in this country, and the child labor has to be prohibited. These are fundamental rights. Right to freedom of religion, another very important aspect of the Constitution of India. And we know that Article 25 to 28, they give us the freedom of religion. And cultural and educational rights of the minorities. Minorities defined in a very loose term, and it's not the minority. So the last, Article 31, Baba Ambedkar has a very interesting comment to offer on Article 31, which I'm going to show you what he has to say on that. And of course, this is a very controversial article now. And right to constitutional remedies, very interesting Article 32, which gives how the rights can be safeguarded and how we can directly approach the Supreme Court if our rights are violated. And the court has a power to issue the writs. And the most important writs is the writs of habeas corpus, which is sort of the basis of the Constitution, unwritten Constitution of the United States. The meaning of the word habeas corpus is, why my body is arrested. No one can be arrested just like that arbitrarily. The state has to show the reason as to why anybody's body is arrested. And the habeas corpus acts, they give us a kind of a convention on which the unwritten Constitution of the United Kingdom is based. So these are just some of the interesting things that I wanted to bring in. You can read it anytime in the Constitution. But rights and remedies, why remedies are important, and what Baba Ambedkar has to say on rights and remedies. So this is what Baba Ambedkar has to say. I'm going to show you what he has to say. But before that, what Baba Ambedkar says is, the Declaration of the Rights of Man, pronounced by the French Constituent Assembly, and the principles which are embodied in it has become part and parcel of the mental makeup. This is what Baba Ambedkar says on 17 December 1946 in his first speech in the Constituent Assembly in response to the objective resolutions put forth by Nehru. And he says that the rights are nothing unless the remedies are provided, whereby people can seek to obtain redress when rights are invaded. It's very important. The rights of men were in circulation, but what is important is the remedies. And I'm going to show you more important than remedies. Remedies are very important, are the principles of justice. Without justice, there cannot be rights. That's what Baba Ambedkar says. So he says there are no rights in the Hindu society which the moral sense of man could recognize. There are privileges for a few and disabilities for vast majority. This is a very insightful statement of Baba Ambedkar. And mind it, it was not a prepared speech. Baba Ambedkar just rose and spoke. He says, but the fundamental rights are opposed by the community. No parliament, no judiciary can guarantee them in the real sense of the word, because the society is like that. The habeas corpus acts declare no principle and define no rights, but they are for practical purposes worth 100 constitutional articles guaranteeing individual liberty. So this is in the context of the UK. This is not the statement of Baba Ambedkar. I just put it to show you that it matches with what Baba Ambedkar is saying. And this is a very important quote. There is a longer quote, but this summarizes what Baba Ambedkar has thought about the law and how that impinges on the fundamental rights. So Baba Ambedkar quotes here, and he says, there is no method found by punishing the multitude, quoting Burke. Law can punish a single solitary recalcitrant criminal. It can never operate against a whole body of people who are determined to defy it. Social conscience is the only safeguard of all rights, fundamental or non-fundamental. So are very interesting statements. We have a beautiful constitution, as we have seen. It's a great document. It gives all the power, it gives rights, it gives remedies. But the society that we live in is, in the moral sense, it recognizes no right of the people, no right of the individuals. And there are only privileges for a few and disabilities for the vast majority. For example, if you pick up Manusmriti, and you will find out what is it all about. So I think this quote is very important. And when we are talking about rights and remedies, we have to talk about fundamental rights, liberties, and opportunities. We have to provide the opportunities for the individuals. So when one reads that part of the resolution, it reminds one of the Declaration of the Rights of Man. And we have seen how important rights of man in the scheme of thinking of Baba Ambedkar, which are pronounced by the French Constituent Assembly. I think I am right in suggesting that after the lapse of practically 450 years, the Declaration of the Rights of Man and the principles which are embodied in it has become part and parcel of our mental makeup. I say they have become not only the part and parcel of the mental makeup of modern man in every civilized part of the world, but also in our country, which is so orthodox, so archaic in its thought, and its social structure. Hardly anyone can be found to deny its validity. To repeat it now, as the resolution does, is to say the least pure pedantry. That's what Baba Ambedkar said. And this is very important. He says, these principles have become the silent, immaculate premise of our outlook. It is therefore unnecessary to proclaim as forming a part of our creed. The resolution suffers from certain other lacuna. I find that this part of resolution, although it enunciates certain rights, does not speak of remedies. So we know when the Constitution came into force, it provided remedies, and this is a longer quote, but very important. All of us are aware of the fact that rights are nothing unless remedies are provided, whereby people can seek to often redress when rights are invaded. So this is what Baba Ambedkar says. And then I'm going to come to the last one. He says, sir, there are here certain provisions which speak of justice, economic, social, and political. If this resolution has a reality behind it and a sincerity of which I have not the least doubt, coming as it does from the mover of the resolution, I should have expected some provisions whereby it would have been possible for the state to make economic, social, and political justice a reality. So you see, the fundamental rights, remedies, and the justice goes hand in hand. Without a just society, we cannot have the rights for the individual. This is a very insightful, and Baba Ambedkar strove very hard to ensure the political justice, the social justice, and he was all for the economic justice, but it couldn't come into being. So just to give you some inkling of the thought process of Baba Ambedkar, we have seen right to personal freedom in the Constitution of India. Right to freedom, it runs from Article 19 to Article 22. But more than that, you look at now, I'm going to show you how broader is the thinking of personality in the scheme of Baba Ambedkar. How broader is the concept of personal freedom in the scheme of Baba Ambedkar. This is what is. So according to Baba Ambedkar, he writes in 1919, the growth of personality is the highest aim of the society. Here, of course, he was very much in tune with his teacher, John Dewey, who says that the cultivation of the personality is the democracy. That's what he defines. Here, Baba Ambedkar says like this: the growth of personality is the highest aim of society. One is as a person is what one is associated with others. This is very interesting. Our personality is not in isolation. We are what we are in association with others. Very interesting, very insightful. One statement, every statement so insightful. Social arrangements must secure free initiative and opportunity to every individual to assume any role he is capable of assuming, provided it is socially desirable. A new rule is a renewal and growth of personality. Government is, after all, an association, and this is of course point number two. So because the government is an association, it must try to seek the growth of the personality. Government cannot develop the personality of the few at the cost of the many. This is what Baba Ambedkar says. Further, he says this is not in the interest of democracy. It is not enough to be electors only. It is necessary to be lawmakers. We always talk about others, that they will be elected, but it's very important just to even the govern. And Baba Ambedkar says that we have to become the governing class. We have to rule. We have to become the lawmakers. So the personality of the untouchable is confiscated. Even today, in many parts of our country, the personality of the untouchables is confiscated. The untouchability arrested the growth of their personality. It also comes in the way of their material well-being. It also deprives them of certain civil rights. So the growth of personality is so crucial. That's so important a point in Baba Sahib's thinking. The socio-religious disabilities have dehumanized the untouchables, and their interest at stake are therefore the interest of humanity. So whenever we talk about the Prevention of Atrocity Act, we are not talking about the class of people who are treated as untouchable. We are talking in the interest of humanity. And this is very instructive. The interest of property are nothing before such primary interest. The social and religious disabilities which dehumanizes, the word is dehumanizes, the untouchables and their interest at stake are therefore the interest of humanity. The interest of property are nothing before such primary interest. So you see, even the personal freedom, the constitution only gives a few articles, but if you look at the writings of Baba Ambedkar, he goes deeper into every single aspect. The constitution has not just came from anywhere. It has come from the very deeper understanding of Baba Ambedkar. So let's at the end we look at the rights and justice. So I said that three aspects are important: rights, remedies, and justice. Together they constitute the rule of law. And as we know that political justice, social justice, and economic justice is a precondition for political, social, and economic rights. And denial of rights is injustice. To deny them, this is what Baba Ambedkar says in the context of the right to vote, is to create a situation full of injustice. So the rights, both fundamental and non-fundamental rights, are so important. They are non-negotiable rights. They cannot be negotiated. And if the society is compromising with that, even if it's an unjust social order, it is not going to ensure the full rights to the individual. And even the remedies will be useless. So this is another long quote, but I'm not going to go into that. I'm going to just going to touch briefly. You can read it afterwards. But this is what is important, that the constitutional lawyers never advanced to the conception that the constitutional law of democracy must go beyond adult suffrage and fundamental rights. So he's talking about the economic justice, because if you look at the fundamental rights, there is the social justice, there is political justice in the constitution, but there is no economic justice. And Baba Ambedkar wanted to make economic justice, economic rights as the part and parcel of the Constitution of India, which couldn't happen, and therefore the directive principles of state policies are there, and I'm going to show you how they are included. So he says old-time constitutional lawyers believed that the scope and the function of the constitutional law was to prescribe the shape and form of the political structure of society. They never realized that it was equally essential to prescribe the shape and form of the economic structure of society, if democracy is to live up to its principle of one man, one value. Time has come to take a bold step and define both the economic structures as well as the political structure of the society by the law of constitution. And he says, other constitution makers have made that mistake. We cannot. We have to include that, but it couldn't happen. And this is what Baba Ambedkar has talked about. Article, actually, this is what is I'm going to talk about. briefly, economic democracy and DPSP. This is what Baba Ambedkar says on 1st November 1948. He says, in my judgment, the directive principles have a great value, for they lay down that our ideal is economic democracy. Because we did not want merely a parliamentary form of government to be instituted through the various mechanisms provided in the Constitution without any direction to what our economic ideal, as to what our social order ought to be. We deliberately include the directive principles in our Constitution. This is the value of the directive principle of the state. They tie down with the fundamental rights. So this is what Baba Ambedkar has talked about, Article 31, which is very important article, which was amended, and Baba Ambedkar was part and parcel of the debate. And this is very interesting. You can look at the larger discussion in the file that I sent you in the group. A very interesting debate on Article 31. But here Baba Ambedkar is very instructive. The drafter, the architect of the Constitution, says that the Article 31, in my judgment, is very ugly thing, something which I do not like to look at. And I exhort all of you to find out what Baba Ambedkar meant by that. That's homework for you. But this is very interesting. Article 31, which gives the right to property. What Baba Sahib exactly wanted is social democracy. And his concept of social democracy, economic rights, is worth look at. And we have looked at them in the previous course that we had on the economics of Dr. Baba Ambedkar. So I would conclude with that. Today we saw in our lecture the understanding of the rule of law and democracy and the rule of law, citizenship and rights and remedies, right to personal freedom. So we have covered a lot of ground in terms of this rule of law. And as you have seen, this is a very, 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 very deeper concept. And it gives us a lot of tools to develop into methods, as Baba Ambedkar always wanted. So with this, I will stop here and open up the class for any discussion.
Uh, well, hello, sir.
Amit.
Yes, I have a doubt that if but the remedies are available,
Yeah,
but the court in the Supreme Court, the cases are 30 years old cases are happening now.
that is true.
So that is a big backlog,
Yeah.
and very few judges, only in a vast country of 100 crore, 140 crore people, only 30 Supreme Court judges are there.
Yeah.
So this if remedies happen after the person dies,
Yeah.
if the
Good
court
point.
case is happening after the person dies,
Yeah.
what is the use of such a remedy? Because
That's very true.
it is not this Baba Sahab's vision was not like this. It's just my opinion. Your comments on that, please.
No, I totally agree with you, because the fundamental rights, the Supreme Court has the power to intervene, and it has got huge powers. And as we have seen that the writs, or particularly the writ of habeas corpus, is so fundamental to the development of the constitutional conventions in the UK. And without this personal liberty or personal freedom, nothing, we cannot, what how do we qualify ourselves as the citizens, right? As we have seen that the citizenship is the bundle of rights, and the most important is nobody can take away our fundamental rights. Even the state cannot take away our fundamental rights, right? So you are right that there is a need to change the judicial system in terms of how it can be done. I think that's a bigger question that we need to think through. But I think it's a problem. These cases has to be handled immediately whenever there are the fundamental rights are violated. And there is a very important, interesting book which is called The People's Constitution. I forgot the name of the author, but it goes into quite a very interesting facts about when the Constitution came into being, how the people knocked the doors of the Supreme Court, when they were the forced labor and all, and how the Constitution became the power of in the hands of the people to ask for the rights. The point here is, Amrit, you are right that this is a there is a need to have a change in the structure, but at the same time there is a need to have more literacy of the Constitution. People do not know their rights, and as we know that the constitutional right, fundamental rights, is so simple to explain anybody, isn't it? It's a commonsensical thing. If nobody can make me slave, right? So anybody has anything to say on this?
And the People's Constitution, is it by Rohit Day?
Yes, it's by Rohit Day. Yes. A very interesting book. So, Amrit, I'm sorry I do not have the answer to your question, but maybe you can yourself suggest some of the things.
And another one thing I want to say is that
Yeah.
there is someone told me about the institutional capture.
Hmm.
That is, some people, some groups of people capture all the institutions by putting their own people into the institutions.
Yeah.
And especially the judges, for example, some judges passed cases favorable to some people,
Yeah.
and they became the member of parliament in Rajya Sabha.
Yeah.
And some people take photos with some politicians. So if the whoever comes to power, whoever becomes the chief justice, they collude with the powers that be and don't deliver justice. What remedy is available to the people? And
that's a very difficult question, and I think that the ball boils down to the constitutional morality. That the people, the politician, whoever they are, they have to work according to the constitution, right? But we know that the constitutional morality in this country, as Baba Ambedkar said, even when he was alive, was not there. People just took fundamental rights for granted as if they are very elastic, isn't it? But fundamental rights are not like that. And as you said, in the context of the judiciary, there was one information circulating which says that the majority of the judges come from a very select few families, right, Amrit?
Yes, sir.
And the Supreme Court of India, they are now even have the political posts, right? They are the members of Rajya Sabha. So these are very tricky questions. But we know what's going on, right, Amrit?
But these are relevant questions because any good system can be made like into this. However good a system is, Ambedkar sir said that the persons running the constitution, however good the constitution is, the persons running the constitution are bad. The situation becomes bad.
I agree with you. I agree with you.
So what can be done is we should brainstorm on it sometime.
Yeah. Are you in the group?
Yes, I'm in the group.
Okay. Good. You raised these questions in the group.
Okay, sir.
Okay, good. Anyone has anything to comment or offer any insightful things?
Yeah. Hello.
Yeah.
Yes. Yes, my question is actually, it is not a question, it is an observation.
Yeah.
That certain states, I think Gujarat state and Rajasthan, they have enacted laws which says that when it is the conversion of religion is not allowed in their state. This is a blatant violation of the freedom of religion.
Yes.
How is it that the Supreme Court has a right? They can strike down such laws. This is a observation is that the Supreme Court doesn't care to do such things. It is their bounden duty to obey the Constitution.
Yes.
So,
it is an anti-constitutional law.
Yeah.
Because everybody has a right to choose whatever religion, profess their religion.
Yes.
Isn't it? And you have to notify to the government and all as to what government has to do with my religion.
Yeah.
So you're right.
Your comments. We don't have any solution when the Supreme Court is not acting against it.
Yes.
Mangesh sir, good evening.
Yeah, Padmakarji.
See, now you have touched the subject of constitutional literacy. But we are seeing that whosoever is a ruler state, they are doing just lip service. They are not actually doing the duty to spread the message of constitution or tell the new generation about this.
Yes.
As a NGOs or like our groups, what we can do to make people literate on constitution?
There are
any action plan we can make?
Yes, there are two aspects. One is like this is what is going on. People are distributing the copies of the constitution across.
Yeah.
So I think it is not just in English, it's legible. English is a very beautifully done.
Yeah.
And every single word is very important. And I recommend the text to be read by anybody who can read English.
Yeah.
For the sake of, knowing, it gives you power. The reading of the constitution gives you power. Also, the Hindi was done by a very great mind who was head of the translation committee, Rahul Sankritan.
Rahul Sankritan.
So Hindi is also beautifully done.
Yeah.
And I think people can read the constitution directly who are there. And for those who cannot read, I think, there is a need to have, the graphical representation, for example, the fundamental rights.
Okay.
Isn't it? And, for example, if you look at the American Bill of Rights, it's very handy. You can have it in a small, leaflet, the Bill of rights. Such is not the case with the Indian constitutional, particularly fundamental rights.
Yeah.
But I think they can be done artistically.
Okay.
And, they can form a small booklet in vernacular languages. Even the dissemination of the fundamental rights can have a far-reaching impact on the lives of people.
Yeah.
So I think we can do that. If there are people interested, artists interested, they should talk more about it. A single article can be like the Article 17, abolition of untouchability. Isn't it? It can be demonstrated as to, how illegal it is to practice untouchability, right?
Yeah.
So I think that can be done by those creative minds, I think.
Thank you, sir.
So anything before we conclude?
Can I ask one more question?
Amrit, please ask.
So there was this Constituent Assembly debates.
Yeah.
It was there. Some of it was there in the Lok Sabha website, in the Parliament website. Now it is taken down. After
Really?
this, now it is taken down. It's not there, and some books were. It was made into book form.
Yeah.
But the books are all sold out, and it is nowhere we can read. Where can we read these Constituent Assembly debates? And which sources of Ambedkar's writings? How can we access that? From where can we access that? Any idea? Please tell us.
The Constitutional Assembly debates were available online for a long time. I've not checked like last 1 year or two, but I used to check them on the online, I think Lok Sabha or Rajya Sabha website. And I got the physical copies of the constitutional debates. They are like huge. They are like, they pile up like this. And they are available in Delhi. I don't know whether they stopped the publication of it. You can check, Amrit, or I will check for you. And all the writings of Baba Ambedkar are now available online, the Ministry of External Affairs website. If you want a physical copy also, they are available very cheaply at very cheap prices.
Which ministry website, sir? Which ministry website?
So Constitutional Vanshika has shared something in the chat box. Constitutional Assembly debate. You can check that. Okay, he has submitted that in the chat box. Okay.
There is Constitutional Samvidhan Sabha debates. It is in Marathi. It is published by Professor Godeswar from Nagpur.
Yes.
But it is in Marathi.
Yes, true.
I am from Tamil Nadu.
I don't know whether they are translated in Tamil Nadu, but it will be a good project to be taken up by the Tamil Nadu government, I think. Maybe you can write a letter to them that make them available in Tamil. All right, then. If anybody has anything to say before we conclude for today.
Hello.
Yes.
The right to health is not yet been included as a fundamental right so far because probably we do not have the adequate infrastructure of health.
Yes.
That probably is the reason. But is it likely that it's going to...
What they have done, what the Supreme Court has done over the period of time, they have included all these things under one article, Article 21, right to life. So right to housing and all, these they are made implicit there. They are not like defined clearly. But the right to life and it has a broad scope. And that's what the Supreme Court has done over the years, over the period of time, to interpret in terms of right to education, right to this thing. But these are all fundamental rights. Right to health is a fundamental right. Everybody has a right to health. Has to have the right to health.
It is not explicitly written there, but it is implicitly included in the meaning of right to life. Okay.
So in the upcoming class, that is going to be our last session. I'm going to try to be a little bit, provocative and innovative there. We will be looking at all this material that we have been studying in the past 5 sessions, and I'm just going to think what Baba Ambedkar would do if he is alive today in terms of the principles of the Constitution that he so has broadly sketched for us and has given us this beautiful Constitution. So stay tuned till the next class, and we will meet next week. So Jai Bhim, and thank you all for joining in. See you next week.
Thank you. Thank you so much.
Thank you, sir.
Thank you. Thank you.